Hey folks, welcome to today's impromptu but necessary, I had to catch up on this, Law of Self-Defense show. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you very much. That's always greatly appreciated. My apologies for the delay. I had to reorganize my desk today and things weren't, I got caught by surprise. Took me a little longer to set up the show than usual. But here we all are. Welcome. Today's show is, of course, my mea culpa, my I'm guilty for a passing remark I made about the Alec Baldwin case recently. This happened when I was a guest on Nick's show, Rekieta Law, covering the Murdaugh trial. We had a few minutes before the trial started up, and the topic of Alec Baldwin came up. Alec Baldwin, of course, had been charged with involuntary manslaughter, reckless manslaughter in the death of Helena Hutchins, and added on top of that was a sentencing enhancement. The sentencing enhancement was actually the big charge. It's not actually uncommon, folks, for a gun sentencing enhancement to carry more time than the underlying crime itself, and that was the case here. So what had happened is the prosecutor in the case had decided to do away with the sentencing enhancement. Waived the sentencing enhancement, leaving only the underlying involuntary manslaughter charge. And I opined at the time, completely my fault, having not thoroughly investigated, but kind of off the cuff, that a quick look at the sentencing enhancement statute for New Mexico, the one that applied here, 31-18-16, convinced me that it should not apply to the armorer, Hannah Guttierez-Reed, also charged with the same crimes as Alec Baldwin here. But it wasn't clear to me. I didn't think that it was necessary to waive the gun sentencing enhancement charge in the context of Alec Baldwin. That was wrong. That was a mistake on my part. So I don't often make mistakes, but when I do make them, of course, I am duty bound to correct them. Yeah, it's been a long day, folks. Sorry, but I do still have the tie. It's not the end of the day yet for me. It's only a little after 4 where I am. So here we are to talk about that. Now, before I jump in, of course, I should mention that the sponsor of today's content is none other than Law of Self-Defense itself, our upcoming Law of Self-Defense Advanced course, a full-day course on use of force law taught live by me, streamed to you at your computer. We're together all day, plenty of opportunity for Q&A, other interaction. Saturday, April 15th. And if you sign up for that class this month, during the month of March, you get 10% off your registration. The purpose of this class, folks, what it does is it makes you hard to convict. It makes you an unattractive target for prosecution. If, of course, you adopt what we're talking about in the class, in the unfortunate event that you're compelled to use force, especially deadly force, in the to neutralize an attempt to harm yourself, your family, your property. Who doesn't want to be hard to convict if you've had to act in what you believe is lawful self-defense? All of us, I think. And you can learn all that in a single day from me personally, taught live, streamed to you, Saturday, April 15th. By the way, if you have a conflicting obligation Saturday, April 15th, I encourage you to sign up for the class anyway. This is the only one scheduled for 2023, folks. The only full day Law of Self-Defense Advanced course scheduled for 2023. So if you miss this one, you're looking probably at 2024. The reason I suggest sign up, even if you can't make the Saturday 15th, April 15th, is because we'll make the playback recording of the class available to all the students. So if you can't attend live on Saturday, April 15th, you'll still have access to the course afterwards. And if you can attend Saturday, April 15th, you'll also have access. This is a fire hose of information, folks. Many people attend this class multiple times, so you'll get to watch it not just live, but for a period of time afterwards in the playback version. I encourage you, if you're unsure, go look at this link, lawofselfdefense.com/advanced. There's a more comprehensive video there from me about the course. We go through the 100+ use of force law questions we answer over the course of the day, most of which I bet you don't know the correct answers to. if you haven't taken this class before. So that's the URL. Sign up in March. By the way, you can also sign up for another person. If you have a loved one you'd like to take the class, you can sign up with their name, and they'll get the registration, the ticket to come to the class. You can do all that and much more at lawofselfdefense.com/advanced. Okay. What else do I need to say? If you have questions you'd like them answered, the usual. If you're on YouTube watching, it needs to be a $5 super chat minimum. If you're on Rumble watching, and we should be streaming this live everywhere, I think. Yep. There's YouTube. There's, I'm not sure yet about Rumble. Law Self-Defense member dashboard. It's on there. And let's see. On Twitter. Unfortunately, we don't answer questions on Twitter. It looks like Rumble. Oh, maybe Rumble is working. It is. How about that? So we're streaming in all the usual places. Rumble, you want a question answered, you need to post it as a Rumble rant, I guess they call it. Again, $5 minimum. Or if you're a Law Self-Defense member watching this stream live, put your question in the chat on the member dashboard. Just preface it with the word question in all caps, and that's free because it's included as part of your membership. And as you know, as a Law Self-Defense member, your membership's only 30 cents a day, less than $10 a month. And you get all your questions answered for no additional cost, not an additional $5 a piece. And any of you can become a Law Self-Defense member right now, this instant, and have the benefit of asking as many free questions as you like after you become a member at lawofselfdefense.com/join. All right. Let's see. All right. Alec Baldwin. So Alec Baldwin and Helena Hutchins, the armorer on the set, have both been charged with involuntary manslaughter in the death of Helena Hutchins for different factual reasons, of course. Helena Hutchins was the armorer, presumably responsible for the safety of the guns on the set and so forth, making sure none of them had a live round loaded in them. Alec Baldwin was the guy with the gun in his hand who actually pointed it at Helena Hutchins when the gun discharged, causing her death. So they've both been charged with reckless manslaughter. Recklessness, of course, being the creation of an unjustified risk of death to another, and then death results. It's different than negligence. Negligence would be a case where you should have known you were creating a risk, but didn't actually know. You didn't deliberately ignore a risk. You were just distracted, perhaps. And negligence, you can kill someone through negligence and be a wrongful death civil suit. No criminal liability as a result of negligence. But recklessness does carry criminal liability. Recklessness is where you knew you were creating the unjustified risk of death and you did the act anyway. And in the case of handling a gun, you're presumed to know that you're creating the risk because we all know that guns are deadly weapons. We all know guns are dangerous. And we all know that guns, if pointed at another person, can cause their death or serious bodily injury. So if you're handling a gun and you deliberately point it at another person and it goes off and kills them, that's the dictionary definition of reckless conduct. And if the person dies as a result, reckless manslaughter. And like many states, New Mexico also has, in addition to the underlying involuntary manslaughter crime, they have a gun sentencing enhancement where they seek to punish people who use guns in crimes at a higher level than people who might have committed the same underlying offense, but without a gun, with a car, with a knife, whatever. And the gun sentencing enhancement here is actually the big one. That's the big gun for the prosecutor, because believe it or not, involuntary manslaughter under New Mexico law is only good for up to 18 months and maybe no time. It's at the discretion of the sentencing judge. So even if Alec Baldwin were found guilty beyond a reasonable doubt by this New Mexico jury, he still might serve no time if the sentencing judge decides he doesn't deserve time. And at the most, he would serve 18 months. The gun sentencing enhancement, however, the one currently in effect, and we're going to go through the history of the statute because the fact that it changed so frequently in just the last couple of years is what led to much of this confusion, my confusion, when I made that off-the-cuff assessment on Nick's show. The current version of that gun sentencing enhancement has a mandatory minimum 5 years for the use, discharge, or brandishing of a firearm in the commission of some underlying offense, in this case, reckless manslaughter. So the reckless manslaughter itself is only good for a discretionary 18 months, maybe no time at all. But the gun sentencing enhancement is a mandatory, no discretion, 5-year minimum felony sentence. So that's the big stick here. And then it got dismissed. The prosecutor in the case a couple weeks ago decided to dismiss the gun sentencing enhancement. And I off the cuff, I kind of thought it made sense with regard to Hannah Guttierez-Reed, the armorer, but it seemed to me to be discretionary to dismiss it against Alec Baldwin. That they might have dismissed it just so they were being consistent with both of those defendants. There didn't seem to me to be a good legal reason compelling the prosecutor to dismiss the gun sentencing enhancement with regard to Alec Baldwin, and that was my error. That was my error. Alec Baldwin has obviously retained excellent defense counsel, and they identified that, in fact, it was not the current gun sentencing enhancement statute that applied to Alec Baldwin. It was the previous version. The previous version was in effect, believe it or not, I think for less than a year. The old version would have applied. I'll call it the original version, the 1993 version would have applied. That was in effect right up into July 2022. Then they had a new version that was in effect at the time that Baldwin shot Helena Hutchins. And then a few weeks later, 11 weeks later, they modified the statute again into its current form. And in its current form, if it applied to that time period in which Baldwin shot Helena Hutchins, he would be looking at the 5-year mandatory minimum. But we don't apply laws retroactively in America. We only apply the law that was in effect at the time you committed the offense. And the current version of this gun sentencing enhancement was not in effect at the time Alec Baldwin shot Helena Hutchins. The previous version was, and the previous version does not apply. That sentencing enhancement would not apply to the conduct of Alec Baldwin in the shooting of Helena Hutchins. Now, I know many of you may be disappointed about this because you may not like Alec Baldwin. You may not like his politics. You may think 18 months is not sufficient time for having recklessly killed a young wife and mother. And I might agree that 18 months to me doesn't seem like a lot of time for that reckless handling of a gun that resulted in the death of a wife and mother. But that's what New Mexico provides for reckless manslaughter. And I believe in due process of law. And I think we're all entitled to the same due process of law. That means you, me, and Alec Baldwin. And if I wouldn't have the current version of the statute apply to me or apply to you, I can't argue for it to apply to Alec Baldwin either. And it ought not apply. So the dismissal of the gun sentencing enhancement against Alec Baldwin was absolutely the right call. The defense counsel's representation that this was well, they don't use this word, but I'll use it, a stupid mistake by the prosecutor to bring the gun sentencing enhancement charge in the first place was correct. They were right. So having laid that all out in verbose verbal form, let's take a look at the actual, a little bit of the motion to dismiss the charge, and then we'll look at the actual versions of the statutes themselves. So here I have, let's see, I have the motion. Let me pull that up. Make that bigger. Okay, so what do we have here? State of New Mexico versus Alexander Ray Baldwin III, defendant's notice of unlawful enhancement and motion not to bind over enhancement. Essentially, they're saying, we don't think this enhancement appropriately applies to our client. We want the court to dismiss it. Let's see. This is, of course, Baldwin's defense counsel writing. The prosecutors in this case have committed an unconstitutional and elementary legal error by charging Mr. Baldwin under a statute that did not exist on the date of the accident. Of course, the statute number existed. It's been a long-standing statute under New Mexico law. What they mean is the version being applied to Alec Baldwin did not exist at the date of the accident. Now, notice they call it an accident. It's not an accident, folks. Not using accident properly as a legal term of art. An accident would be a bad thing that happens, and there's no fault. There's neither civil nor criminal liability because there was no way to foresee the bad outcome. That might be, say you're carrying a box that happens to have a gun in it. Your boss says, could you move that box from that side of the room to the other side of the room? And you're carrying the box, and unbeknownst to you, there's no indication of this. No one told you. There's no labeling on the box. Inside the box is a loaded firearm. And you get distracted for a moment. You drop the box hits the ground, discharges, and kills somebody. Somebody getting shot from you dropping the box was a completely unforeseeable event to you. There's no way you could have known that risk was being created. That's an accident, and there's no civil or criminal liability in it. Now, maybe you worked in a company where lots of boxes had loaded guns in them. Let's imagine a crazy, crazy business. Well, then someone might argue that, well, you didn't actually know there was a loaded gun in the box, but you should have known because many of the boxes you carried around had loaded guns in them. That might be grounds for negligence. You didn't actually know, but you should have known that you were creating the risk. Recklessness is if there's labels all over the box, do not drop, loaded gun, could discharge if dropped. And you allow yourself to get distracted and drop the box. Well, arguably then you know by not paying close attention, due circumspection, as the law might call it, you were knowingly creating a risk of the gun discharging. That would be recklessness. That would cover negligence, would apply only civil liability. Reckless could be used for really either because reckless includes negligence. So recklessness would be civil or criminal liability. This was not an accident. When you're holding what you know to be a real gun and you point it at another human being and you don't first ensure that it's not loaded with live ammo, you know that creates a risk. We all know that creates a risk. We all know we wouldn't want that gun pointed at us. We all know that if the script had called for Alec Baldwin to point the gun at his own head, he would have checked to make sure there were no live rounds in the gun before discharging that gun. So you know when you're pointing at a real gun. Now, if Alec Baldwin had managed to claim, oh my gosh, I had no idea that was a real gun. I thought it was a replica. I thought it was a weighted rubber facsimile. I had no way to know that was a real gun that was going to discharge. That would have been a great defense. But he would have had to have said that from the start. And he knew from the start that it was a real gun. You can't credibly raise that defense afterwards, especially after all his talking with the media. So they call it an accident. That's just clever by the defense. It was not an accident in legal terms, but of course they would like the world to perceive as if this was an accident. Accidents happen. It's nobody's fault. Well, if it's anybody's fault, it's not Alec Baldwin's fault, not our client's fault. The motion continues. The information, this is the charging document. A lot of states use informations instead of getting a grand jury indictment. So you can have basically investigators swear out an affidavit attesting to the facts that present a prima facie probable cause fit with the elements of the underlying crime. So that's what they used here in information. They did the same thing with George Zimmerman, for example. They didn't put his case in front of a grand jury because if they'd done that, they would have the grand jury might have seen the contesting evidence and not returned an indictment. So they just used an information. In that case, the information was full of falsehoods and lies that were never argued at trial. So it was a defective information, but that's how it goes. Prosecutors get away with that all the time. All it cost George Zimmerman was any remnant of a normal life and many hundreds and hundreds of thousands of dollars in legal fees and a real risk of going to prison for the rest of his life, where he certainly would have been murdered as soon as he got there. But prosecutors don't really care about that kind of thing. So the information states that the second alternative, some prosecutors, most prosecutors I know are good people. Some prosecutors don't care about that. They're politically motivated. Continuing, the information states that the second alternative count of involuntary manslaughter shall be enhanced pursuant to firearm enhancement statute 31-18-16. But at the time of the accident, which was on October 21st, 2021, the firearm enhancement statute applied only when a firearm was brandished in the commission of a non-capital offense, and it defined brandish to mean displaying or making a firearm known to another person while the firearm is present on the person of the offending party with the intent to intimidate or injure a person. The government's statement of probable cause contains no allegation that Mr. Baldwin acted with intent to intimidate or injure a person, and its description of the alleged conduct makes clear that the tragic death of cinematographer Helena Hutchins was an accident. Again, it wasn't an accident, but they're correct that there's no evidence that Alec Baldwin, in pointing the gun at Helena Hutchins, however reckless that conduct may have been, that he did it with the intent to intimidate or injure Helena Hutchins. There was no brandishing, or at least there's no evidence of brandishing in this case. And we're going to see just how damn lucky Alec Baldwin got. Because if he had committed this conduct a few months earlier or a few weeks later, brandishing would not have been required. Mere use or discharge of the gun would have been enough to trigger the sentencing enhancement. He just happened to fall into about a 1.5 year window of time in which use and discharge had been removed from the statutory language and only brandishing was in there. And in fact, the brevity of time that version of the statute existed, the one that only applied to brandishing, did not apply to use or discharge, strongly suggests to me that the legislature made a mistake. Because for decades earlier, use or discharge was enough for this sentencing enhancement. Then suddenly it was only applied to brandishing, not to use, just brandishing. So if you tried to scare someone with a gun, you'd get the sentencing enhancement. But if you actually discharged or used the gun, you wouldn't. That doesn't make any sense. So I think the legislature just made an oopsie. But it's the responsibility of the legislature to draft the laws in such a way that normal people understand what legal liability they're incurring under those statutes. And it looks like Alec Baldwin is fully entitled under due process of law to the benefit of the version of the, I think, mistaken statute, or I should say unintentional statute, the version of 31-18-16 that was in effect for only a very few months. So I'm not going to go through the entire motion here. I haven't added it to the description of this live stream, but I'll add it after the show's over. And as I say, this was the motion, basically a request to the court to dismiss the sentencing enhancement. And of course, this was provided to the state as well. And it appears to me the state independent of any court order, they didn't leave it up to the court. They just saw this motion and saw they were in error, and they just dismissed the sentencing enhancement themselves. Kind of in an immature way, actually, because they released a press release and they said, listen, we just want to focus on the crime itself. We don't want to argue about the sentencing enhancement. But the truth is, the defense is right here. When the defense says the prosecutors in this case have committed an unconstitutional, an elementary legal error by charging Baldwin with this gun sentencing enhancement, the current version of it, that the defense is right. This was an unconstitutional and elementary legal error. Prosecutors should have known better. This was them really dropping the ball. Okay, so let's take a look at the actual statutory language. Let's see if I can make this bigger for everybody. So we start with what I'll call the 1993 version. And this was in effect until July. I lost my mouse cursor. Oh, there it is. Until July 2021. Now, keep in mind, the shooting of Helena Hutchins occurred on October 21st, 2021. So the old version of this was in effect until July 1st, 2020. So a little more than a year, right? Because until July 2021 would be a year, August, September, October, 13 months. Up until 13 months prior to the shooting, this was the version of the gun sentencing enhancement. And it applied to use, brandishing, or discharge of a firearm. So the relevant paragraph is so this version, the 1993 version of the gun sentencing enhancement, differentiates between brandishing and use or discharge, or I should say brandishing or discharge. So, and that makes sense, right? If someone merely waves a gun around in a threatening way, that's bad. That should warrant, I guess, a gun sentencing enhancement. But if they actually fire the gun, that's worse. So it should be more of a gun sentencing enhancement. And the 1993 version of this gun sentencing enhancement statute reads, when a firearm was brandished in the commission of a non-capital offense, the sentence shall be increased by 3 years. And if a firearm was discharged in the commission of a non-capital felony, it shall be increased by 5 years. So this was the version of the gun sentencing enhancement in effect until 13 months before Baldwin shot Halyna Hutchins. But in July 1st, effective July 1st, 2020, there was a new version of 3118. That is this version. In effect only from July 1st, 2020 until May 18th, 2022. So not even 2 years. But this captures the October 21st, 2021 shooting event in which Baldwin shot Halyna Hutchins. So this is the version of the gun sentencing enhancement that applies to Alec Baldwin. And it applies to brandishing of a firearm. Now, the title of the statute doesn't control how the statute's applied. That's in the actual language. But we look at the actual language, and it applies when a firearm was brandished in the commission of a non-capital felony, the sentence shall be increased by 3 years. There's nothing here in any of the statutory language about use or discharge. That language disappeared. Now, did Baldwin discharge a gun? For sure. Did he brandish a gun? They have a definition here, I believe, of brandishing. Brandishing means displaying or making a firearm known to another person while the firearm is present on the person of the offended party with intent to intimidate or injure a person. And there's no evidence of brandishing here. And this is the version of the statute that applies to Alec Baldwin, the version that only takes into consideration brandishing, not discharge of the firearm. So it's inapplicable to Baldwin's shooting of Halyna Hutchins. Now, this was only in effect until May 18th, 2021. And the shooting was October 21st, 2021. So we have October, November, December, January, February, March, April. 6 months later, the current version of 3118.16 comes into effect May 18th, 2022, and it reapplied use or discharge as conditions that triggered the gun sentencing enhancement. Included it in the title, and we also see it in the actual language. When a firearm was discharged in the commission of a non-capital felony, the basic sentence of imprisonment prescribed for the underlying offense shall be increased by 5 years. This is the version the prosecution thought should apply to Alec Baldwin, but they didn't check the effective dates of it. And so when they charge Alec Baldwin under this version of the statute, that's an attempt to apply a statute, a law, retroactively, backwards in time. This was not the version in effect on October 21st, 2021, when Alec Baldwin was shooting Halyna Hutchins. It was the version of the gun sentencing enhancement that applied only to brandishing, not to discharging the gun. Almost certainly an error by the legislature that they fixed in the current version of the law, but the current version doesn't apply. And that's where we are with that. I don't know. It was kind of a stupid mistake. It's really a stupid mistake, especially, I mean, it's not that hard. It's not that hard to know. So, for example, let me pull this up. I wonder if can I pull this up without disclosing my account information? Yeah, I think so. Whoops. Let me pull this up. This is my Lexis account. So, you know, any real lawyer has a Lexis account, or maybe they have easy access to it in their building or in local courthouse or whatever, legal library. But this is my account. By the way, it costs thousands of dollars a year to have a full-blown professional Lexis account, but it's worth it. I do it all for you, folks. I do it all for you. So here we go. You have New Mexico Statute 31-1816, and by default, when you go there, it is, of course, the current version. But as you scroll to the bottom, you get additional kind of historical information, and they talk about the various amendments to the bill. And the 2020 amendment changed the 1993 version by substituting brandishing for use. Took away use, also took away discharge. And replaced with brandishing. And then in the 2022, the current version added use or discharge back into the statute. So, you know, the prosecutors, presumably they're going to read the statute before they charge someone under it. And if they're using professional resources to do that, you'd think they'd take a look at the amendment notes. So certainly I would, if I had been actually doing a show on this topic as opposed to having an informal discussion with Nick Rekieta while we're waiting for a completely separate trial to start up, certainly I would have checked. But I didn't check prior to making the offhand remark, and that is on me. So that's what I wanted to correct here today. Let me take a quick look and see if there are any questions that have come in about this. It was a very late notification, so I'm not sure. I don't expect much. Let's see, nothing from the members. Check for super chats. Let's see. Corn Pop didn't ask a question. 3 separate $2 2 super chats and 1 super sticker. Well, that adds up to more than $5. Thank you very much, Corn Pop. That's greatly appreciated. That was the only one, and nothing on yeah. So Alex, I should say Alec. He's Alexander, but like some Alexanders, they go by Alec with a C on the end. So shoot me. Sorry. So that's it, folks. So with that, I will wrap up today's relatively short show, just over half an hour. I want to, of course, thank you all for being here. Don't forget about our Law Self-Defense Advanced class, Saturday, April 15th. Go to lawselfdefense.com/advanced to learn more. And until the next time, probably tomorrow, remember, if you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill, so my family is hard to kill. You also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until tomorrow, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.